gathering today. On behalf of Tirado International Business School, GIBS, we extend our gratitude to Chairman Sir Shri Arvind Jindal, Vice Chairman Sir Shri Anirudh Jindal, Dean Ma'am Ms. Prachi Jindal, Director Sir Shri Dr. Professor Vikas Nath, and our special dignitary from overseas, Mr. Joe Tirado, faculty members and students.
Today's event, Beyond the Courtroom, Mastering Modern Dispute Resolution, is not just a discussion, it's an opportunity to embrace the future of conflict resolution. As we move beyond the traditional litigation framework, we explore innovative techniques such as mediation, arbitration, and negotiation, methods that redefine how disputes are resolved with efficiency, intelligence, and collaboration.
Before we begin, let's take a moment to acknowledge the institution that has made this insightful event possible.
Tirado International School, GIBS, is a premier institution dedicated to academic excellence and holistic development. Established in 2004, GIBS is affiliated with Guru Gobind Singh Indraprastha University, Delhi, and is and is approved by All India Council for Technical Education for technical programs, as well as the Bar Council of India for law programs.
The institution offers a diverse range of programs including MBA, MBA International Business, MBA Integrated, BBA Honours, Integrated, BA LLB Honours, Integrated BBA LLB Honours, and LLM, with a strong commitment to quality education. GIBS has been consistently recognized for its excellence and is being graded A by NAAC in its third cycle.
Now, let's turn our attention to the distinguished expert who is with us today to share his valuable insights on modern dispute resolution.
We are honored to have with us Mr. Joe Tirado, an internationally recognized international arbitrator, mediator, and ADR consultant with over 30 years of experience in dispute resolution.
Having held global leadership positions in leading firms across 4 major jurisdictions, the UK, the US, Illinois and Texas, and Spain, Mr. Tirado is now a full-time independent international arbitrator, mediator and ADR consultant. His practice spans across more than 65 jurisdictions, where he has handled hundreds of cases across diverse industry sectors as counsel, arbitrator, adjudicator, expert determiner, mediator and conciliator.
Mr. Tirado has represented sovereign governments, multinational corporations, and high net worth individuals in high value and complex disputes. He has conducted and advised over 100 international commercial and investment arbitrations under all major arbitration groups, as well as more than 50 mediations and other ADR processes.
Consistently ranked among the top professionals in international arbitration and ADR, Mr. Tirado has been described as first class and best known for his work on energy-related disputes, financial services, and public international law. He is a solicitor advocate with full rights of audience in England and Wales, a CEDR accredited commercial and investor state mediator, a civil mediation council fellow, and a former SID conciliator appointed by the President of the World Bank Group.
Beyond his extensive practice, Mr. Tirado has contributed immensely to the field of international arbitration and ADR. He serves as a contributing editor of Global Legal Insights to International Arbitration, now in its 10th edition covering 67 jurisdictions. He has been actively involved in arbitration and mediation institutions worldwide and has held leadership roles, including as a past co-chair of the IBA Mediation Committee.
With his vast expertise and contributions to legal scholarship, we are truly privileged to have Mr. Joe Tirado with us today. Without further ado, we invite him to take the stage and share his insights.
Let's welcome him with a huge round of applause.
Namaste, good morning. Nice to see so many of you here. Thank you very much for coming, and thank you very much indeed for the invitation to come and speak to you today. It's a very broad topic. I was excited because there are so many aspects to it, and basically the title is Beyond the Courtroom, and looking at all forms of alternative dispute resolution. I'm going to be candid with you. I'm going to focus primarily on international commercial arbitration, but there's obviously a whole range of ADR services topics to discuss. Now, I hope this is being billed more as a seminar than as a lecture, because I do very much hope that you will contribute and we will work together so that as I'm going along, if anything is not clear, you want to raise a question, I would encourage you to do so as we're going along rather than saving it until the end. But there will be opportunity to raise any questions or comments at the end as well. So please do, don't make me feel lonely out here and it's just one-way traffic. I do want you to contribute. It's a great opportunity. We all learn that way. Me included. That was a very kind introduction. It always embarrasses me slightly because it just makes you realise how old I'm getting, because you get that kind of experience with going around the block a few times. But nonetheless, people see things differently. You will see things differently, and from a different perspective that makes me pause and think. And I think that's how we all learn. So please do feel free to chip in. So as I say, I think what I'm going to do is look primarily at international arbitration for a relatively short time, as an hour. There's a huge amount to go through. So I think it wouldn't be, thank you, sir. It wouldn't be fair to just try and do everything in one go. I think some of you have already covered the subjects and will know the basics anyway, but I think if we can just assume, I'm assuming a relatively blank sheet, so when I'm talking about international commercial arbitration, but there will be overlaps as going through, and I think probably have an issue with the terminology. I mean, we talk about ADR often as being the alternative, but actually I think, personally, I prefer the term appropriate dispute resolution. So there, some people kind of, particularly when we're talking about mediation, some people have been rather more concerned and scathing and believe that ADR stands for an alarming drop in revenue. But actually I think that kind of suspicion or concern is misplaced for reasons we'll touch on as we go through. But I'm just going to go through, what is international arbitration? Excuse me, I think I've got control of the switch, so do I need to? Yeah, sorry. Would you mind, actually, could somebody, if I hand this to you and I would say next slide, when to litigate or not or arbitrate, types of international arbitration, applicable law, creating an enforceable arbitration agreement, some specific issues to consider with commercial arbitration, some conclusions and opportunity for questions and answers. That's the primary thrust. Is one of the, in terms of one of the processes of ADR, which is commercial international arbitration. The reason why I choose that is, and perhaps next slide please, is that I think it's pretty much without, I think, uncontentious to say that international dispute resolution is the primary dispute resolution mechanism for international contracts, transnational. You do have obviously domestic arbitration in different jurisdictions, but invariably people tend to revert to international arbitration for reasons that we will talk about. So primarily the next point is that it's to provide neutrality, is to try and effectively create a level playing field that everybody feels comfortable in, or equally as uncomfortable. Inevitably, if you feel you are before the courts of your opposing party, you're going to feel at a disadvantage. You're going to feel perhaps that you don't really understand the processes. You may actually feel that you're going to be actively discriminated against, and therefore, obviously, a reluctance to go to a local court. A lot of that depends on your negotiation strength when you're entering into the agreements as to whether or not but this is often one of the things that might be traded in order to get an agreement done, where somebody say, okay, I will go to your court, but generally the default position is, let's try and agree a neutral venue that we're both comfortable with. And that will may well also reflect in terms of the location. And you may well typically choose somewhere, so if you have a contract with an American party, Indian party, you might choose somewhere in Europe or the Middle East, at least somewhere that physically may well be in between. But as I say, it's essentially to provide a neutrality and equality of arms, if you like. It's an adjudicative process, so in that respect it's not very alternative. We're going to stick with the alternative definition to litigation. It's effectively, I always describe it as a private form of dispute of litigation. You have a private judge as opposed to in many jurisdictions a publicly judge is provided by the state. So it's not that different at the end of the day. And I think one of the biggest criticisms of international arbitration, since it's really taken on board, is the fact that it's mirroring ever more the court process, and in particular the Anglo-Saxon way of doing things, which kind of causes a bit of umbrage to the civil law jurisdiction. So it's not that alternative, but that's why I think that it's important that we do spend a few moments, and I'm sure that you will have some questions and observations about the. I'm hearing a lot of chatter. Sorry, I should just explain. I've been very fortunate over the last 25 years to be to India on quite a number of occasions and work with Indian clients. It's been fascinating for me to see every time I come how things are evolving, and certainly it's had a bit of a bumpy road with regards to the for arbitration, notwithstanding the fact that Indian parties often are in some of the biggest arbitrations, both commercial and investor state. Historically, they've had a bit of a kind of, I think, slightly schizophrenic view as to the approach to arbitration, as to whether they really want to go for it or not go for it. But that's changing, and I think it's moving all in the right direction, and I think there really seems to be genuine aspirations and moves, I would say, to creating an arbitration hub in this part of the world, and there's no reason. But in tandem with that, and most recently I'm hearing a lot of chatter in particular about mediation as a real alternative, and we'll touch on that in a moment. But obviously one of the other advantages of arbitration is that, to all intents and purposes, it's private, more often than not. Often most institutions won't publish who the parties are. The reality of it is things have a habit of leaking, either deliberately or by accident, so you can't hope that it's necessarily confidential. But essentially that's what it's designed to do. So it's to do your dirty washing in private rather than in public in the court. So that's a kind of a general overview. Next slide, please, sir. So when to litigate or arbitrate. There are many factors, where the parties are from, location of assets. That's really important because in many ways you've got to look at the end of the process at the very beginning. And I think that all too often people forget to do that. You can have the most beautifully crafted process, and then at the end of the day, all you get is a piece of paper. You've still got to go and enforce that somewhere. And so knowing where the enforcement is going to take place, and it generally is money more than anything else, is really important. But that may well determine whether you arbitrate or litigate, for reasons we'll come on again in a moment, the nature of the dispute, and what are the alternative jurisdictions. Some jurisdictions you may well feel can give you the quick the quick justice that you're looking for. You're happy, you think it's you understand the process, it's neutral enough. So those are factors, but generally arbitration may be appropriate, as I've already mentioned, to establish a neutral forum. London is still, I'm pleased to say, but only just, the world's leading arbitration centre. It still is, but there's a lot of movement on this, and certainly what we have seen, and it will resonate here, and perhaps no surprise with an Indian audience, Singapore has grown considerably over the last 20 years, and now, in terms of the latest statistics available, equals London as the most popular venue for an arbitration. So that's interesting, and there's going to be a new survey at the end of this year, beginning of next, and it will be interesting to see whether London actually slips back and Singapore pulls away. And that happens, that evolves. It used to be Paris was the place to go. Geneva was also very popular as an international arbitration. And so things have a habit of moving around, but London has pretty much dominated this particular space for the last 20 odd years. It's also, I would say though, where it has its advantage not only in international arbitration, it's arguably the world's leading international dispute resolution centre, so that will include mediation, and we do quite a bit of international mediation. I do quite a bit of that. So it's kind of the holistic view, and of course the courts are still very popular. We have something like, I think it's well over 50% of the parties in our commercial courts are actually foreign parties. So it's often perceived as a good neutral venue from, to go to courts. But other important jurisdictions are still Hong Kong, Paris, Geneva, I've already mentioned, New York. Often courts have a very lengthy, complicated, they have their procedural rules, and all of this may well, the more complicated it becomes, the more involved it is, the more costs are involved, and that's obviously an opportunity to look for something alternative. And arbitration was always sold as the mechanism that was potentially cheaper and quicker. The reality of it is that has things become much more complicated, and again that perceived advantage has reigned over the years. But I still be an optimist. There's still a lot of ability, and I think with the right tribunal in place, but you need a coalition of the willing and everybody to be pulling in the right direction. It's still possible to have relatively quick, relatively cheap arbitration. Another thing is the ability to choose your tribunal expertise. Often in a litigation in court, you just get whoever is on the roster. And it never always used to fascinate me that you might be, notwithstanding the fact I would be, most of my work was in, well, all of my work was in the commercial space. If you go before a judge, you may be actually, the judges for you may have actually had their prior career, the way it was in the UK. You practice first until you're a pretty senior advocate, and then you get asked if you'd like to be considered as a judge. But many of those might have been criminal lawyers, have nothing to do in the commercial world. And a little bit hit and miss as to who you might get. So it's a bit of a lottery, whereas you can actually have the opportunity to select your tribunal that has expertise, or at least a familiarity in the project, in the area of dispute. The other thing is that you get, generally speaking, it's a one-stop shop. It's a bit brutal. That's good if you win. If you think, I don't want to do that. Less so if you lose. But generally speaking, the scope for appealing an arbitration award is extremely limited, and getting ever more limited, other than really issues of due process, which I think we can all understand, ensuring that there is fair play. Whereas courts may have one more layers of appeal, so that will add to the cost, the complexity, and the delay, and spin things out. Also, well, I've already touched on confidentiality. Enforcement is arguably the biggest single, I think, difference between an court and arbitration. And the reason why I rarely use PowerPoint these days, actually, and the reason I'm doing this, I've dug this old one up, because I think it's helpful that sometimes a picture really does say more than 1,000 words. This is a little dated, but this is the world when the UK was still part of the European Union. That's all the blues are. And the reason I put that is that because this was actually perhaps the peak in terms of our ability to enforce UK judgments. And you would see a lot of this tallies with Commonwealth countries. So this is where you were relatively, there's always exceptions, and as you look at the detailed individual, but generally speaking, with an English judgment, you could go to any of these coloured countries and would relatively easily get your judgment recognised and enforced in the home jurisdiction. So of course, if you're dealing with international disputes, as I said right at the very beginning, the assets might be elsewhere. So it's good that you might have this regime. And I flag us because actually we are, to my knowledge, this is probably the most comprehensive regime for enforcement of judgments anywhere. It's a little bit dated, as I said, because it has the colour blue. We're no longer in the scenario have the beauty of the blue, but it's still pretty extensive. Compare that to this. Oh, hang on, sorry. Sorry, you need to go back to the... You got the map? Next page, please. Next. No, hang on. You've lost. There's no map. No. Is it worth me waiting? No, there's no map. But you can go and enforce an arbitration award. Again, there's always, it depends on the jurisdiction, but generally speaking, there are something like 100, it's over 90% of the signatories to the UN have signed the New York Convention. Is the humming here or is it next door? Is it me? But, sorry, it's just I'm not sure if the noise is coming from outside or inside. But you can hear me okay, can you? It's a little bit distracting, but it's also, I'm not quite sure. Is there an issue? No? Okay. So the point is, I think one of the biggest advantages is the enforcement of arbitral awards, which at the end of the day, as I say, once you take your piece of paper, you want the practical aspect of being able to enforce it. But there are some disputes that are not capable of arbitration at all. The law will prohibit it. Sometimes it's maybe tax disputes, so you may not even have that option. It may be that one of the parties doesn't have capacity to enter into an arbitration agreement, and that will often be the case with state parties where they need special authorization. Generally between private parties that's okay. Sometimes you really need the coercive action of a court. Ultimately courts can fine you, or in the worst case scenario, hold you in contempt and can throw you in prison. And that has happened in an international arbitration where the court is supporting, as I've already mentioned, may have a good court system that will help. Also, arbitration can be a little clunky. It's not impossible where you have multiple parties. It's really better for bilateral private disputes or just a few parties. And it may be that you want that right of appeal. As I said, if you're the losing party, you may want to have another bite of that cherry. But you know, be careful what you wish for, because you certainly have more costs associated with that. And generally speaking, in arbitration, it depends, which is different from here. The general rule is the loser pays the winner's costs, and that's often spelled out in certainly in the English Arbitration Act. So there's an important incentive there to all of this. So whatever significant costs for you to engage in arbitration, there is a real risk that if you were to lose, well, even if you win, you may not recover all your costs. They're always in the discretion of the tribunal, so be careful how you handle your case. But if you were to lose, there's a very high chance that you'll be awarded. You may well be awarded, get a cost order against you. Which will significantly increase costs, and it's not unusual to have multi-million-pound cost orders on top of whatever damages is awarded in international arbitration. They're essentially just moving on to types of. So we can move on. We're going on to types of international arbitration. I can speed up, and we will just look at mediation in just a moment. We've got essentially commercial arbitration is really a creature of contract. Investment arbitration that I've alluded to before, that India got whacked several times very badly in investor state, that it often these are much, by definition, I think, involved in the party. They're much more public. It's in the public domain for obvious reasons of transparency, but they tend to be big disputes, big projects, big money, and so they catch people's attention. And it's developed as a jurisprudence. It's quite complicated. Invariably, what you see now is an overlap between investor, state, and commercial arbitration, and often you can have the two running in parallel. I'm not going to get too much into the details of that, but it's a very interesting area that we've seen huge development. And in India, if I may say so, having had that negative experience and been on the wrong end of it, I actually have been leading the field in terms of developing new bilateral investment treaties and modernising all of that. And people have followed India's leaders to, well, hang on a minute, we need to tweak it here, tweak it there, and that's happened all over the world. Sadly, as I said, it's been learned through the experience of having the wrong way of learning, if you like, but the important thing is learning from those lessons, and that's been certainly the case of cases in particular jurisdictions like Latin America, in Argentina, Venezuela, that have had high number of claims against them. They've now become some of the leading practitioners in the area, as I say, because they've had to learn on the job and their own way. But and then you have institutional arbitration, or ad hoc, and the institution is essentially there to administer the process. Ad hoc is you don't have an institution, But generally, the benefits of having it administered, of course, it comes with costs. There are people there that are doing the administration, but they're relatively a small part of the overall arbitration. Provides efficiency, impartiality, support, and institutional credibility, that neutrality that perhaps arguably best known as the ICC, and also and the disadvantage tends to be the cost that I've mentioned before. There's some of their processes may increase delay, and also some of them tend to be a bit patchy. Even good ones can go through phases where they're not so good, and they move on. So if we can just move on to the next one. So I've already mentioned which institutions. ICC, very popular. SIAC, Singapore International Arbitration Centre, has really become the dominant force in this part of the world. Hong Kong still is significant, but London Court of International Arbitration, there are hundreds of them around the world, and some are, but there are some really well-known ones. Mumbai is made, I think, perhaps the most visible externally in International Arbitration Centre, so which is a very impressive facility, I have to say. There's no reason at all, going back to some of the comments I said right at the very beginning, why India shouldn't become an arbitration hub in itself. But be careful when you want to be choosing arbitration institutions that are well known and will be there when a dispute arrives. But they generally, most of them provide you with the rules that you need to follow. They've done all the work for you. They basically tell you how to set up an arbitral tribunal. They will generally include some provision, not all, but most will include some provision on the level of confidentiality that's expected, the requirements of the award, issues about costs that I've mentioned before, and some will also administer what is a UN model form of arbitration called unsupervised arbitration, and they will administer those even though they're not formally part of their rules. Next slide, please. I just mentioned ad hoc very briefly. Ad hoc is, as I said, unadministered. The difficulty is you're flying solo, so it's the difference, if you like, between having something off the peg and this is more tailored. So you wouldn't really do an ad hoc arbitration unless you're dealing with parties who know how it all works and are prepared to do the heavy lifting. The reality of it is I don't think it's cost effective. There is a value in having the institution to turn to, and they will often, they can be helpful both to an arbitrator when you have an issue that arises, or if you're a counsel thinking that your arbitrator is taking too long, you can say to them, what's going on here? Is there a problem? Are they unwell? Can we put some pressure on? Now, a good institution will already be putting pressure on the arbitration and making sure keeping it going, but that can help save face, keep the impartiality, and not people not feel that they're disadvantaged in themselves by confronting the tribunal direct. But generally, it's not for the faint-hearted and for those who know what they're doing, as I say. If we could just turn to questions of applicable law. The next slide, please. It should. Okay, it's not there. You can find the slide that says applicable law, but all I just wanted to flag here is that often, when you read a standard form arbitration clause, it's no more than 4 or 5 lines. And in terms of the language, it is, but almost every word has been considered, I guarantee you, by literally hundreds of people around the world when they come to drafting these model clauses. There's a weight to all of these clauses. And there's a reason, because it's actually far more complicated than meets the eye. I mean, it never ceases to amaze me when I remind myself of this, is that there are a whole range of laws that apply. I mean, one issue is, I've mentioned already about the question of capacity. Does a party have the capacity to arbitrate? That may be one law. The arbitration agreement itself is an agreement within an agreement. So whatever the contract is about, the arbitration agreement is considered to be separated from that main agreement. Often the terms are identical in terms of the substantive law, but it essentially exists on its own. So if the rest of the contract collapses, because there's a termination, for example, the arbitration agreement still lives, because it's that agreement that will determine the issue of the determination. So there's the arbitration agreement, there's the arbitration proceedings itself. They need to be a control mechanism, and that's the significance between having a seat in place of arbitration, which is a legal term of art. That effectively means that when there's a problem, this is the court we would go to and look for help. And that's why it's very important that you have a supporting court judiciary that will help, not get in the way, but actually help the arbitration process. So whether you need assistance in compelling a witness to attend, or enforcement in some other respect, that's important that you choose the right jurisdiction. If you choose the wrong jurisdiction, you could be in a real mess, and of course will use any excuse to try and reassert themselves, because some courts really don't like the fact that they've had their sovereignty usurped, if you like, and it's all been dealt with in the private sector. The actual law of the dispute itself could be a different type of law. So I benefit from being in English law, that a lot of international contracts that still provide for English law. That's perceived as a kind of safe, stable, relatively predictable law. And so you will see disputes between a party in Latin America and a party in America providing for English law. So neither of them are expert in English law, but that's where they will go to determine the disputes. And lastly is the, but it's not an exhaustive list, it's the question of enforcement. All of this, I think, at the end of the day, you've got to, as I say, I repeat, look at the end of it, because it may well be that you may have issues enforcing your award, because there'll be some jurisdictions that are, let's say, unreliable in terms of enforcement, and will abuse the public policy exception that exists under the New York Convention to say, well, we're just not going to enforce. We'll come up with some spurious argument, but basically we're not going to enforce any award in our jurisdiction that's against one of our nationals. I'm sorry to say, we were one of those. It's not anymore, it's changed. But it's interesting, as countries become more net exporters of capital and they need the system to work for them, they have changed their approach. But that's been part of the, I think, the concern regarding Indian arbitration. Indian courts have still struggled, but are coming around to supporting arbitration. You've had moments where you think you're making progress and then the courts will intervene and kind of somehow undermine the work that's going on. But that's changing in this process of evolution. There are new amendments to the Arbitration Act coming through, and I think the judiciary are certainly getting the message finally. And I think India as a whole is finally accepting the concept of arbitration as something that is actually good for them and to pursue. So that's the kind of overview of international arbitration, because as I said, it's so important. The slides go on to talk about having enforceable arbitration. I didn't want to completely dominate the conversation. The alternative, and I think it is much more an alternative, when I was talking about appropriate, you need to remember you have a menu of options, and I think the really good counsel are those that know that you have those options. So I'm very keen that we have a mixed audience here. I gather it frustrates me all too often that talking to other lawyers, you're just preaching to the converted, if they agree with you, but you're certainly already preaching to those who know. Whereas I think those that are on the management side, who are going to be the future clients, disputes hit the bottom line of any business. They are a real issue that should not be ignored, in my humble opinion. And in one way, I'm kind of arguing against myself and doing myself out of work. It never staggers to amaze me how often I get work, and I get a lot more work because somebody hasn't drafted their arbitration agreement properly, and you're having to kind of untie all that mess. In one level, that's fantastic. But on the other, in reality, that's not what people want, and they come to you to resolve their dispute, and they can help themselves, I think, by being forearmed and aware of what's available for them. And I think particularly with mediation, there is a real opportunity to be much quicker, much cheaper. And this is where you have a third-party neutral that basically assists parties in their negotiation policy. So unlike Trump, who's holding himself out as a mediator in the Ukraine-Russian war, we all saw the disaster when he basically mixed up his negotiating hat with a mediator in full public glare. But essentially, it truly is a third-party neutral that makes no decision whatsoever. And all they're there to do is to try and bridge the gap. And really what they do is, I think, try and coordinate it in a way that parties, because invariably you only see things from a certain lens, and you only have a certain amount of the truth sometimes, and you're able to kind of change perspectives when you have active engagement. So it's fundamentally important that you have the right mediator going forward. There's a huge amount of chatter here that I'm hearing, not only in this room, but in India, about the benefits of mediation. I think it's very encouraging to see whether or not this is what is going to benefit, will actually take hold here and go forward. There's a lot of enthusiasm. There's a lot of people at an event last night, all mediators at the Supreme Court, very keen to promote it. But I think clients and the future clients will be the real key to ensuring that mediation is successfully adopted in this jurisdiction. And again, there's no reason why India shouldn't become, because again, Singapore is kind of taking the lead, a major hub for mediation in its own right. And it has significant benefits in terms of, as I say, saving costs both on the time and the cost of the proceedings. They often last a few days. Enforcement is not normally an issue because parties agree. Their settlement agreement is not something that's being imposed by a judge or an arbitrator. So there's a lot to be said for mediation. And in my view, there's almost no cases where it's not appropriate to use. I'm not going to say it's going to resolve all cases, but I will just conclude comments on mediation by saying, if you don't believe me or persuaded by it, the statistics globally, I think are worth taking note of. You often see settlement rates, certainly in the UK, something like 75% of cases settling on the day, 75, I repeat that, and then another 13 or so, 13 to 15% settling within a short time. So you're not far off 90% success rate where it's actually used. But the key thing for mediation, one is timing. It's not always appropriate to do it the first thing. Often it is, and you will have a contract which will say this is the dispute resolution as part of a tiered way of going towards arbitration. You will at least have the option of mediation. But I think it's certainly very encouraging here, and I'm more than happy to take any questions or hear your observations as to where you see the future of ADR going. But certainly I think court litigation, disputes are here, it's a fact, they're here for, they're not going to go away. But looking for alternative, not only alternative, as I say, alternative appropriate forms of dispute resolution, I think is very much the key going forward. And it's important that we're aware of all of that. So I think without further ado, I think I'm pretty much up with my time. So I'm more than happy to take any questions. If is there anything that wasn't clear, any comments, anybody disagree with anything I said, happy to take it. No?
They see arbitrators and mediators as their opponents. In the international arena, is that a thing that the traditional litigators and the advocates, they see mediators and arbitrators as an opponent or as someone who is going to help them?
Good question. That's evolved as well. There are the die-hard litigators who are, that's what they're proud of, and they're there to go to them. My American colleagues would say they're trial lawyers, they're there to go and argue the case to the court. It's more about them than about the client. Actually, they have the opportunity to perform. It's all very dramatic, and they would think there's no other way of doing justice than that. That's changed, that's softened certainly, but you will also get those arbitrators that are very similar to the litigators. You get those litigators that will consider arbitration, will often say it's litigation by another name, and almost do exactly the same tactics. So I'm not sure there's such a friction between arbitrators and litigation other than I think, saying there's a discrete area, and that certainly has changed over years. So when I started, very few firms had any standalone arbitration departments. There were very few people doing international arbitration on a full-time basis. That's changed now. There's a lot more. The mediator one's a more interesting one. I think that's kind of the one where it's perceived to be, well, it's not really, it's a little bit soft. I think it has a public, I say this quite regularly, Nate, these days. I think mediation has a public relations problem. Perceived as a bit soft, a bit cuddly. I think the emphasis on the consensual, consensus, amicable gives the wrong impression, because it seems to be hugely extensively in family matters, employment matters, but there's a sense that it's not appropriate for big, serious, complex commercial matters. And actually, the reality of it is it's quite untrue. But I think it's much better, because you can concentrate on parties' interests rather than right, to create settlement solutions that are far more creative than having a black and white arbitration or judgment. So, but interesting that's moving. As mediation is now becoming more kind of commonplace, and clients are, all importantly, asking for it. There's a recognition, actually, you know what, there's maybe something in this. So the reality of it is, some people can wear multiple hats. They're relatively few, and they should be, because I think you need people who know the distinctions. You know when to be a litigator, you know how to be an arbitrator, and there are really subtle differences between them. But invariably, you still will have kind of specialist counsel in both. But I think that has that distinction is beginning to break down, certainly with mediation and litigation. So I hope that's kind of answered your question. It's a bit generic, because of course it depends where you're talking about, and people are at different levels. But essentially, no, you're right. There are three grounds. But I think from a client perspective, and you as counsel, as most people in the law school will be doing, need to be able to talk to clients and give them the options. There's another lecture going on over there. It's obviously better than my one. Thank you.
Hi, I'm Srishti. I have a question. Like, we see that the artificial intelligence is developing so much, right?
Yes.
So what do you think would be the role of artificial intelligence in international as well as domestic arbitration?
Yeah, well, great question, and a real topical one. Nobody knows. I mean, I think one thing we know, it's coming, it's here. And one thing we know, it's changing at an alarming rate. The biggest fear is the selfish one, that everybody thinks it's going to do them out of the job. And the reality of it, there are some that without a doubt is a powerful tool and a power for the good. But as with most things, there are goods and bads with everything, because you can save an enormous amount of time in terms of research and preparing work. But you need, and there's a real temptation, because as I was saying, in terms of being given presentations, how to be successful in the career, and of course there's a big expectation, you have to be excellent at what you do consistently, but you have to do all of that within a really tight time frame. So there's a temptation to want to cut corners and frankly cheat. I don't see this cheating, and it's perfectly legitimate to use AI, but you need to be extremely careful, because it gets it wrong. It wants to please you, and it will generate and indeed invent cases that don't exist. And there have been cases where people have been caught out. I was reading just the other day, the American lawyer who got caught out and admonished in a court in New York, which is sanctioned for not having checked effectively. So beyond any negligence claim, this was a professional sanctions regime, and there was also a lot of other people involved that were sanctioned for not having picked it up. So it's a very interesting area. I think for me, it could theoretically determine a dispute, and you could theoretically do without a judge. I'm not sure if that's much different from just tossing a coin. I think dispensing justice has a human element. And maybe I'm old school, I just can't get my head around. If it's me, I would want my day in court, I would want my sense of justice, I would want to be heard. And I think that the federal words of human as a discretion. How do you determine somebody's demeanour? How do you credibility? A lot of cases are, he said this, she said that, and you need to be able to determine. I'm not sure that AI gets to look at your retina and see whether you're lying, whether you're perspiring. I think you just need to be careful. And there's certainly, I think courts are becoming a lively. It was just last week in Australia and in the Caribbean. to have prohibited use of AI to things like witness statements and affidavits, because they should be coming from the words. They quite accept that it can be used for the preparation of briefs, but so long as that's not compromising the accuracy of what's being forward. So it's definitely a force for good, and I was reading somewhere else, a law firm in the UK has teamed up with Harvard, and they've now come up with an AI that can help people prepare for cross-examination, which again is a real skill and an art. If anything you can do, particularly when but often a lot of this gets done overnight. You've been all day in a hearing, you're exhausted in preparing for the hearing, you've gone through the hearing, and then you've got overnight to prepare your cross-examination. Anything that can help you in advance, it's got to be a good thing, but it's definitely here. And then I think on that level, I think India obviously has a tremendous tech industry, and I would not be surprised, in fact I would expect a lot of Indian enterprises here to be part of that revolution. Thank you for the question.
What role do you think mediation can play in resolving commercial disputes?
What role?
What role do you think can mediation play?
Personally, I think it's huge. I don't honestly think, whether you go as far as mandating mediation or say, look, before you come to the courts, which in most jurisdictions is a public resource, it has to be, it comes out of tax, you will all be taxpayers, those that aren't taxpayers, coming out of your pocket, people running to the court when there are other potential means of resolution that are proven to be effective, I think is an abuse of the system. Now, it may be that your case can't be resolved, and there are some cases like that, and that's what you have the judges there for to deal with it. But I think it has the potential to be a complete game changer. And we are seeing that in some sectors, in some jurisdictions, but it's a hard sell. And I don't understand why it's such a hard sell, because it's so self-evident to me in terms of the cost and time saving, as well as the personal wear and tear on people's engagement. It has a real, and that's why there's so much enthusiasm for it in, I see here in India, because it can be a real game changer. But I don't see it as an either or. I see it, as I was saying before, as part of the menu of options that parties have available to them. And all I would just say is, if it doesn't say, I don't believe in a failed mediation. At the very least, in preparing for mediation, you know your own case better, because you have to have that formality. But it may be that it doesn't settle there and then, but you've already started a chain reaction, that it may be the next day, the next week, so it may be several attempts. So it's never too late. Even after an award, before you're waiting, rather after a hearing, before you're waiting for a judgment, there's still scope for having, what you're getting with mediation is certainty. You know what you're having, whereas with any litigation arbitration, it's a lottery. Ultimately, it's a lottery. You try and stack the odds in your favour as best you can, but it's a lottery. Okay, ready? Last chance?
I have one more thing to ask.
Sir, go on.
I don't know if it is an appropriate, but here in India, people, the lawyers, the upcoming litigators, they're all very money-minded. So I was just trying to ask that this particular field of arbitration and mediation, does this compete with the traditional litigation in terms of income, in terms of money?
Well, yes, compete on it. It's definitely, it can be quite lucrative. You often have, as you would litigation, it's a specialist area. I think where litigation has an advantage is that the processes themselves are more complex, you spend more time, the appeal process, which you don't generally have with an arbitration. But investors, where it is significantly different, and where the money suddenly starts going up, the averages, this is obviously not their subject, is about 15 million for a case. It's not unusual. Pakistan got hit for 25 million recently. The money's enormous. But the money, the council at a very high investor stage. That's a kind of slightly more esoteric but increasingly common area. So, no, I think you can make money both, and I think those are the small. But,
I'd like to request Siddiq Singh, the former president of Legal Aid Training, to come on stage for the appreciation for his amazing work during this tenure. Can you please answer that? Please, sir, can you please appreciate this? Also, we would like to request Srishti Bansal, the former Vice President of the Legal Aid Clinic, to come on stage for appreciation of her efforts during her tenure. Thank you so much, sir.
What an enriching session this has been. We are truly grateful to Mr. Joe Tirado for sharing his expertise and deep insights with us today.
His knowledge has not only expanded our understanding of modern dispute resolution, but has also inspired us to explore innovative approaches to legal practice and business negotiation.
Before we conclude, we would now like to invite our respected faculty, Dr. Nidhi Sharma ma'am, to kindly deliver the vote of thanks.
A very good afternoon to one and all present over here. So on behalf of Mediator International Business School, I take this opportunity to propose vote of thanks to those who have directly and indirectly contributed to this guest lecture on Beyond the Courtroom, Mastering Modern Dispute Resolution. At the outset, I would also like to thank our resource person, Mr. Joe Tirado, for his commendable effort in conducting this guest lecture. We are really enlightened with your knowledge and presence, sir. We are thankful to our Honorable Chairman, sir, Vice Chairman, sir, and Dean ma'am for their continuous support and motivation. I would also like to thank our faculty, students, and IT team for tremendous support. Heartfelt thanks to our students for active participation. With these warm words and a kind message, we move to the end of today's guest lecture. Thank you so much.
Dr. Nidhi ma'am to present the memento and green welcome for this. We extend our sincere gratitude to our faculty members, the organizing committee, and all our students who have made this event a success.
Thank you all for being a part of Beyond the Courtroom, Mastering Modern Dispute Resolution. Wishing you all a great day ahead.